Hi, everyone, and welcome to Legal Diagnosis, the podcast where law meets healthcare. I'm Liz Sullivan. I chair our healthcare practice group here at McDonald Hopkins. McDonald Hopkins has been serving healthcare clients across the healthcare continuum for more than 50 years. And I'm so pleased today to be joined by two of our senior members from the healthcare practice group, Jane Pinewood and Emily Johnson. Just a little bit about Jane and Emily. Jane has been counseling healthcare clients on regulatory and business matters for over 37 years, first here at MH as a partner, then serving as Chief Legal Officer of BioReference Labs. And finally, we had the pleasure of welcoming Jane back to our healthcare practice team here at MH recently. Emily is a member of our healthcare practice group and a partner here at McDonald Hopkins. She maintains a robust healthcare practice, advising clients on regulatory and business counseling matters, as well as advising clients on HIPAA compliance, including breach notification and response, and interfacing with the Office of Civil Rights. Prior to joining MH, Emily served as a healthcare attorney and senior consultant with a national legal-based healthcare management consulting firm, and she served as outside counsel to the National Association of the Boards of Pharmacy. So each podcast, we're going to break down the legal pulse of healthcare and pathology and the pathology and lab industry. What's new, what's next, and what you need to know. In just about 20 minutes, we're going to cover hot topics, compliance headaches, and regulatory shifts that we see shaping the field. Plus, we are going to be joined by legal pros, healthcare insiders, and industry leaders who bring real-world insight to the table and our discussions. Today, we want to talk a little bit about the recent court decision relating to the FDA's attempt to regulate laboratory-developed tests. So with that, I'm going to turn it over to Jane to get us started. So let's get into it.
Thank you, Liz. On March 31st, the District Court for the Eastern District of Texas granted the plaintiff's motion for summary judgment, throwing out the FDA's final rule, which was the FDA's attempt to regulate laboratory-developed tests. The American Clinical Laboratory Association, along with HealthTracks, had filed suit against the FDA. In addition, the American Molecular Pathology, as well as Dr. Michael LaPosada, had filed a second lawsuit. The court consolidated those two lawsuits, and both of the plaintiffs had filed a motion for summary judgment, asking the court to throw out the final rule, stating that the FDA had exceeded its authority in attempting to regulate laboratory-developed tests. And on March 31st, the court agreed with the plaintiffs. The court threw out the final rule in its entirety and remanded the matter back to the Secretary of Health and Human Services for reconsideration. What's important here, particularly if the FDA decides to appeal the final rule, and as of the moment we're doing this podcast, it's uncertain what the FDA will do. Obviously, on a federal level, our federal healthcare agencies have a lot of staffing shortages. There's a lot of uncertainty. It's a very unstable time for those associations, or those agencies, So it's very uncertain what the FDA will do. But if the FDA decides to challenge and appeal the court's decision, then the FDA will have to address the court's findings in the motion for summary judgment. Importantly, if we begin with what were the important points found by the court looked at the definition of medical devices. The FDA has the authority to regulate medical devices, but not a professional practice like the practice of medicine. So the FDA cannot regulate the practice of medicine, but it can regulate medical devices. So the key question here is a laboratory-developed test a medical device? The court spent a lot of time looking at the definition of medical device, looking at the Food, Drug, and Cosmetics Act, looking at the Merriam-Webster's dictionary, what's a medical device? The court decided that a medical device is what we would think of in common parlance. It's an instrument, it's a reagent, it's a thing. In contrast, the court said a laboratory-developed test is a series of services that have been put together. They may use equipment and instrumentation, but is a series of services that have been determined by a laboratory director, who often is a physician, could be a PhD, but often a physician, and that is not of the same substance as a medical device, means that not the same character or quality as a medical device. The court also looked, importantly, at the legislative history. Court looked at the legislative history of the Food, Drug, and Cosmetics Act and of CLIA. And as some of you know, there have been various attempts over the years to expand the regulation of LDTs, including acts called Valid and Vital. Court looked at the legislative history and decided that Congress has put the regulation of laboratory developed tests at this time within CLIA, not within the FDA. In fact, the court went on to say that in the 50 years since the enactment of the Food, Drug, and Cosmetics Act, the FDA really didn't take any action until sometime in the 90s. And even then, it's been sporadic. The court thought it was very important to note that, until this past year, with the proposed rule regulating laboratory developed tests and now the final rule, the FDA never really took any action in all those 50 years that it said it had the authority to regulate laboratory developed tests as medical devices. I think the court found that to be a bit of a preposterous position. The court also looked at what would be the impact of the final rule upon patients and the industry. First, the court said, if you take the FDA's position, the FDA says that all of these thousands of laboratories, these many, many thousands of laboratory professionals have all been acting illegally for 50 years. They've all been performing laboratory developed tests. And the only reason that they've gotten away with it is that the FDA has exercised its enforcement discretion not to go after them. And the court said, that just doesn't make sense that you would have an entire industry that would be operating illegally, but for enforcement discretion that the FDA could change its mind at any time. Court went further and said, if industry is operating in that kind of environment, how does one continue to make investments or develop and test? The court looked specifically at laboratory developed tests as being on the forefront of a lot of laboratory test development in the oncology area and in other important areas. It's a laboratory developed tests that are modified to keep track of developments and offer the most up-to-date testing. So the court said if the FDA's final rule went forward, it would very much have a chilling effect upon the development of new tests that really are critical for patient care purposes. The court also explained that it just didn't find the concerns regarding the patient jeopardy that the FDA has talked about in actual history. There may be some anecdotal incidents, but the court didn't find that this is an industry rife with patient jeopardy or inappropriate care. Finally, the court said that the framework of the final rule, which was the FDA said it regulates everything is under the FDA's authority with respect to laboratory developed tests, with only some carve-outs for enforcement discretion that the FDA could change at any time in its sole discretion, that was not a way to operate, to have anything where the FDA could at any time change its mind about enforcement discretion in a matter that the FDA says not only has civil but could have criminal ramifications is simply not a way to regulate. So thus the court decided to vacate the final rule in its entirety and remand the matter to the Secretary of Health and Human Services for further consideration. What I also think is interesting here is if one goes back to the proposed rule that the FDA had come out with a bit more than a year ago, at the time, we all thought that was very comprehensive and probably was overreaching, but it was not as comprehensive as the final rule. So it would have been interesting if the FDA had stuck with the more narrow approach of the proposed rule, what the court would have decided in the same motion for summary judgment. Maybe we'd be at the same place, but I think the FDA's broad reach here to basically take an across-the-board position that we can regulate everything was what the court found particularly problematic. Perhaps the FDA may go back later, working with Congress or others to have more focused legislation, but who knows?
Mm-hmm. That was super helpful, Jane. Sounds like the court answered a lot of the questions that were kind of out there as a result of the FDA's action. From your perspective, is there anything that the court sort of left untouched at this point?
There is. I think it's important as what the court's decision is, which everyone has been lauding. It's really important to recognize what the court did not rule upon and did not touch upon. The court's decision applies only to laboratory developed tests and the FDA's authority over laboratory developed tests. So first we have to begin with, what did the court define as a laboratory developed test? It would be the most narrow definition of what we would also all call a laboratory developed test, which is a test developed and performed within a single laboratory for testing that is referred to that laboratory. The court said very specifically, a laboratory developed test does not include a test kit that might be put together and commercialized and sold to be performed by someone else. And I think that is very important. Because many people are saying, oh, this court ruling means the FDA doesn't have authority over laboratories, but that's not true.
Right.
For anyone who already has an FDA-approved test, that either their own test for which they've secured FDA approval, or they are utilizing an FDA-approved test kit, the FDA still has authority clearly over those items. For traditional medical devices, things that we might have as laboratory equipment, reagents, and I'll talk about reagents a little bit more in a moment, reagents and other items such as that, yes, the FDA would have regulatory authority over those because they're considered traditional medical devices. An area that will be interesting to see what happens, and that is for laboratories who have substantial intellectual property. They may have developed some important algorithms or other AI applications that go into their test. Some laboratories have tried to avoid going through the FDA process, and they have licensed their intellectual property to other laboratories. It will be curious to see how those licenses might be considered, because the court said a laboratory developed test does not include a test kit. But it did not completely define what a test kit is. I mean, there was an explanation. The court, talked about a test kit as basically being everything, the recipe that would be needed to perform a test that would be sold to someone else. Well, some of these license agreements become very, very close to that, where there's a license of the intellectual property, and there may be substantial assistance with respect to what would need to be done to bring a test up in another lab and validate it. So for those laboratories that are licensing their intellectual property, and in essence, to use the parlance out there in the community, people say we're using a channel partner to perform our tests, because that's often a phrase that we hear. I think those could be at risk if the FDA looks at more traditional enforcement in other areas that would not be touched upon by the court's decision. Direct-to-consumer testing is another one. Direct-to-consumer testing, where here I'm talking about someone is going on a website and they're going to order testing. Well, we know in general patients don't order testing. Physicians, other authorized providers order testing, but patients can go and they request a test, and there will often be an asynchronous order by a telehealth network behind the scenes where the order is then placed for the test. Some of these have very substantial follow-up with patients. There's a very robust telehealth provider to provide pre-test and post-test counseling and advice to the patient. But there are many of these where there really is no significant or even real involvement of a healthcare provider. And the FDA has expressed traditionally concern regarding testing in some areas, particularly with some of the genetic testing, where patients may get a test result and start to take action upon the test result because they're not adequately informed about what that test result might mean and whether the patient could suffer some harm by jumping to conclusions and taking some actions. And those can involve FDA approved tests, or they could involve laboratory developed tests. They're really agnostic. It's the direct to consumer platform where there may not be robust physician involvement, particularly on a post-test area where the FDA has expressed concerns in the past, and regulation in that area still would not be affected by the Eastern District's decision in this case. So those are some of the areas where they're not affected at all, and we'll just have to watch to see what happens.
Awesome. Thank you. Well, huge win for labs overall. And I think, with some of our clients in the digital pathology space, there was concern about how it would impact pathology groups as well. Any thoughts there?
I think digital pathology would be very interesting. And maybe again, some of this is supposition. We're going to have to wait to see where the FDA goes with things. And to be honest, who's left within the enforcement agency as well to see where they go.
Right.
But I'm going to divide the digital pathology into two segments. If someone is developing a digital scanning platform with the associated software, the hardware and software, and then wants to sell it and commercialize it, I think to be conservative, we're going to say that's probably a medical device that would have to go through FDA approval. It's like a piece of lab equipment that's being commercialized with the hardware and the software. That's different than a pathology practice, which either has purchased or has developed its own digital scanning platform. And the concerns using, what if we are using this digital scanning platform? Does that mean our professional pathology services utilizing the digital scanning, the digital pathology, or remote pathology, is all of that subject to FDA review? I would like to take the position, and I'm not the only attorney taking the position, that should not be subject to FDA review. And this is the argument I'm making. I can't say that the FDA is in agreement or not, but that digital scanning, looking at slides digitally, remotely using the digital remote pathology networks, that is a tool to assist the pathologist, that we're still talking about the practice of medicine. If a pathologist is not comfortable with the digital image, a pathologist can always request the glass slide and look at the glass slide under a microscope, that this is simply a tool in support of the practice of medicine and therefore should not be under the purview of the FDA. Given the language in the court's decision with respect to laboratory developed tests and its concern that even there, looking at LDTs, it was getting very close to a professional practice in terms of how an LDT is put together, I would expect any court that is looking at the Eastern District's decision might also look at digital pathology in this area as a support tool for professional pathology to fall in the same area that would also be safe from FDA oversight. One other thing I should mention is many clients have been concerned. May 6th, which is coming up very closely, was the first date under the final rule for the phase out of enforcement discretion. So the FDA had said that for all LDTs, starting May 6th of this year, they would have to comply with the FDA's medical device reporting requirements. Given the Eastern District's decision now, assuming one's test is not already subject to FDA approval, a laboratory would not have to comply with that May 6th date. That was part of the FDA for its laboratory developed test that was part of the phase out. And I neglected to mention that earlier. But I think overall, it's certainly as Liz and Emily and I have been chatting about this, our clients are quite pleased. This really was going to have a stifling effect with many, many, many of our clients with updates to their existing LDTs, because clients were very concerned that one of the carve-outs of enforcement discretion was for existing LDTs, assuming that they were not substantially modified. So a lot of clients were very concerned about how they might update their LDTs and whether that would kick them out of some of the enforcement discretion and require them to go through an FDA approval process. And that would have a very negative impact upon patient care, because those are the kinds of tweaks and improvements that laboratories make all the time to keep their tests current with developments, particularly in the oncology area. So that's very good. And I don't think we'll see that chilling effect we did before. Another was simply from the dollars and cents. And certainly for anyone listening to this podcast knows the margins in laboratory medicine can be very, very narrow. And you start looking at all the additional costs. The estimates per test of what it would cost to go through FDA approval were running from $1 million to many millions of dollars per test to go through the process. That's an expense that many laboratories would not be able to cover. And in fact, the FDA, in its preamble to the final rule, acknowledged that a lot of laboratories would cease performing testing, and many smaller laboratories might even cease to exist because of the costs involved.
Third, Kyle.
Yeah, I think that's a really good point.
I think for anyone listening to the podcast, we will obviously be monitoring this. Certainly, there are individuals within the FDA who have spent many, many years of their career being concerned about the quality of laboratory developed tests, whether or not that's warranted. You know, I may have my own personal opinion that it's not, but they still do hold an opinion that this is an area where additional regulation is warranted. So I don't think we've seen the end of this. For those areas where the FDA still has regulatory authority that weren't touched by the final rule, there are a lot of things on the edges there that the FDA is proactive about. And certainly there could be additional legislative efforts. You know, FDA working with sympathetic members of Congress. There are still a number of patient advocacy groups that also believe that FDA oversight would assist patients. I think some of those advocacy groups may not understand how laboratory developed tests are able to, the flexibility and how they're so timely able to address the evolving scientific and medical environment to improve testing. You know, instead, they're just concerned that there may be a lack of oversight, which hurts patients. But to the extent that those advocacy groups may have that misimpression, they may also continue to put pressure on the FDA as well as members of Congress to look at additional ways to regulate LDTs in the future. So laboratories still shouldn't, although you can breathe easy for a while now, monitor the situation because we really don't think it's over yet.
I was going to say, so if you're a lab now trying to prepare for what's next, obviously continuing to monitor it, are we setting aside costs to have to potentially go through the FDA approval process if this is sort of turned on its head and we go back to where things were before the court's decision? What do you think?
I think it depends a bit upon the lab, but if a laboratory is going to have a handful of specialized tests and no more than a handful of tests, it still may make sense to consider whether going for either FDA approval or even New York State CLEP. Because one of the areas of enforcement discretion, and I think one large area where no matter what happens, we still may see a carve out, and that is for tests that have the license to run the test from the New York State Department of Health. Even the FDA recognized that New York State Department of Health has a very, very robust review requirement, which is per test. It's not for a lab, it is per test. And I think laboratories, particularly those that are only going to have a handful of tests, may want to think preemptively while they have the time now, while they may have some funding and the pressure's off, to consider whether going down the path of FDA approval, or if they want to get into the New York market anyway, they're still going to have a New York license to do any testing from New York. So at least consider that pathway may be a reasonable one to take. If you're a laboratory and you're doing 1,000 LDTs because you're a large laboratory doing all kinds of testing, financially, that just may not make sense.
Thanks, Jane. Thanks, Emily, for those great comments and all that feedback. I think just to put a finer point on it, you know, one of the things that jumped out to me in your discussion was the idea that, you know, there's some feeling that this isn't over. So labs really do need to be thinking and planning ahead. And the idea that the FDA, you know, still has an interest in laboratory developed tests, but it's going to look different, likely, as a result of this ruling. And so they may pivot back to some of the core, you know, oversight that they've done in the past. And so for me, you know, hearing you talk, Jane, about the idea of the algorithms and the proprietary information and sort of the consulting or counseling that might happen when one lab has what it truly is a laboratory developed test, but is interested in, you know, possibly sharing that or licensing that. I think to me, that seems like that might be an area where there is, more FDA attention, considering sort of the goals and the aims and the authority that they, have retained post this ruling. So that's just something that I certainly would be thinking about and looking towards. And I'm glad that you highlighted that. And certainly, Emily, digital pathology is very intertwined with some of that idea of licensing and providing other types of tools to laboratories and pathology groups. So thank you.
One additional area as well where the FDA has in the past exercised enforcement and may continue to do so as well, because it's also not touched by the final rule. And it was an area that the FDA it was not touched by the court's decision. And it is an area that the FDA discussed in the final rule. That is the manufacturing and commercialization of reagents. We all know that many manufacturers of reagents put an RUO, research use only, designation on their reagents, saying, because this is for research use only, we, the manufacturer, do not have to secure FDA approval for the reagent. Well, wink, wink, nod, nod, because we all know that those reagents are sold for clinical diagnostic purposes. They go into LDTs, and they are essential components of LDTs. About a year or so ago, the FDA did issue a warning letter to one manufacturer of reagents saying, you may have labeled this RUO, but all of your marketing materials talk about how this reagent can be used for clinical diagnostic purposes. So clearly, you're not selling this for research use only. And I think that's also an area where the FDA may be looking at these large manufacturers and saying, come on, you need to, get with the program. And if these are really being commercialized for diagnostic purposes, you're going to need to get the FDA approval.
Right. Wow. That's so interesting. So Jane, I know you're following this. Our firm is following this. You're going to be speaking about this coming up at the Executive War College. Do you want to just give a snippet about who you're speaking with and what that panel is going to discuss?
I'm speaking with Sheila Wolkoff, who is a former attorney within the FDA, now has her own consulting firm, Goldberg Strategies, and Valerie Palmieri, who's a well-known healthcare executive, and she has her company, Momentum Consulting. And we're going to be talking about the decision, the court decision, but then looking at what does this really mean for laboratories. So we're really going to focus upon what are the areas that remain untouched by the court's decision, where laboratories still need to be concerned, and then focus upon looking forward where, using our best guess, a crystal ball, might laboratories want to go with possible applications for FDA approval and or New York CLEP, just to, cover everyone's bases and hedge the bets, so to speak, and looking at what may be 1 year, 3 year, and 5 year planning for laboratories. So
great.
We hope folks can join us for that presentation.
Yes, I'm super exciting.
Wonderful. All right. Well, that is the first episode of our legal diagnosis podcast. So thank you to Emily and to Jane for your insights. If you have questions or want further information, just head to McDonaldHopkins.com. We have additional content and there's certainly information on Jane and Emily there. So thank you all.